Good afternoon, everyone. Welcome to the World Trade Organization. The panel welcomes delegates from the countries of Alderan and Coruscant to this panel hearing on the dispute Alderan, measures concerning permanent magnet generators for windmills. First, I would like to introduce myself. My name is Angela Ellert. I am Deputy Director General of the WTO, your panel chairperson. I will let my fellow panelists introduce themselves.
Good afternoon. I am Jennifer Hillman. I'm a professor at Georgetown Law School and a fellow at the Council on Foreign Relations.
Good afternoon. I'm Gracia Marindran, Associate Professor in International Economic Law at UCL Law Faculty and also member of the ELSA Academic Board.
Hi, my name is Victor Crochet, and I work as an associate at Van Bellen Bellis in Brussels, and I'm also a PhD researcher at Cambridge University, and the case author.
My name is Peter van den Bossen, and I'm Director of Studies of the World Trade Institute in Bern.
My name is Isabel van Damme. I'm a partner at Van Bellen Bellis and a visiting professor at the College of Europe in Bruges. Thank you.
My name is Marcus Gustavsson. As you know, I'm case author number 2. I'm otherwise based in Brussels. I work for the legal service of the European Commission.
Sorry, returning. I will now ask each team captain to introduce members of the team, starting with the complainant.
Madam Chair, distinguished panelists, good afternoon. My name is Robert Matic, representative of the government of Coruscant, the complainant. I'd like to begin by presenting my co-counsels, Ms. Julia Bachmann, Mr. Mattia Brucker, and Ms. Kayla Lee Kutsie. Together, we represent the complainant in this matter. Today, there are several issues before this panel regarding the AS.
Okay, just one comment about the mics. When your mic is on, it's sometimes difficult for these mics to come on too. So just be aware as well of the red light when you see the red light on the mic. Let me ask the respondent to introduce the members as well, and then we will proceed with the arguments. Okay, thank you.
Madam Chair, I'm really sorry, but the team did not introduce their appearance. They will state a basic structure of their arguments and they will indicate how much time each speaker would allocate for so I believe they were not done yet with this part, and afterwards the respondent will proceed with theirs.
Okay, thank you. We'll do that then. Sorry about that. Please proceed.
Madam Chair, distinguished panelists, my co-counsels and I intend to address the measures at issue in the following order. First, I will spend 14 minutes elaborating why the provision of land by investor X constitutes a subsidy under Article 1 ASCM and is inconsistent with Article 3.1 A ASCM, as it is in fact contingent upon export performance. Second, Ms. Bachmann will spend 17 minutes elaborating why the loan by Zurich's bank constitutes a subsidy under Article 1 ASCM and is inconsistent with Article 5C in conjunction with Article 6.3c ASCM because it results in serious prejudice to the interests of Coruscant. To conclude, Mr. Brucker will spend 14 minutes elaborating why Alderan's measures on neodymium are inconsistent with Article 11.1 GATT because they constitute an overarching measure that systematically restricts exports. Ms. Kutsie will not be presenting any submissions today. With the panel's permission, Ms. Bachmann will spend 5 minutes presenting the rebuttal.
Thank you very much. And now, counsel for the respondents.
Distinguished members of the panel, Madam Chair and representatives of Coruscant, good afternoon. My name is Charlotte Ons, and together with my co-counsels, Ms. Mignolet and Ms. France, We represent the government of Alderaan, the respondent in this case. Today, my co-counsels and I will respond to the claims brought before the panel by the complainants. First, we will address the alleged violations under the Agreement on Subsidies and Countervailing Measures. Ms. Mignolet will address the Ms. Mignolet will address the provision of land. Then I will address the loan granted by the Riksbank and the alleged serious prejudice that was caused to the interests of Coruscant. And finally, Ms. Franse will address the alleged violations under the General Agreement on Tariffs and Trade, also known as the GATT Agreement, the export tax of 25% on the exportation of neodymium, an export registration requirement, and the non-renewal and refusal of mining permits of neodymium mining firms. Regarding time allocation, Ms. Mignolet will address the provision of land in 12 minutes. Then I will take 17 minutes to address the loan granted by the Riksbank. And finally, Ms. Franse will take 16 minutes to address the alleged violations under the GATT. In the end, we reserve 5 minutes for Ms. Mignolet to represent the rebuttal. Thank you.
Thank you very much. Timekeepers, are there any anomalies in the oral statements made by the delegation heads and their team appearance sheets?
No, Madam Chair, everything is in order.
Thank you very much. At this point, we would like to hear submissions from the complainant. Timekeepers, you may commence timing. Thank you.
Madam Chair, distinguished panelists, Coruscant's economy is in a critical state. Its biggest PMG producer had to let go of numerous employees. Its vital PMG production has been diminished to a great extent. This is the consequence of the actions taken by the government of Alderaan. Under the veil of true cross-border subsidies, Alderaan makes a concerted effort to subsidize its own PMG industry. Under the veil of a transition to an allegedly greener energy production, Alderaan has deprived our economy of neodymium, the key input material for PMGs. In reality, this severely hinders the global sustainability endeavor, and therefore Coruscant has no other choice than to seek its rights before this panel. Madam Chair, distinguished panelists, turning to the first claim, it is the position of my government that the provision of land constitutes a subsidy under Article 1 ASCM as all of the cumulative requirements are fulfilled. First, we submit that the provision of land constitutes a financial contribution. As the appellate body established in U.S. large civil aircraft, the second complaint, a direct transfer of funds under the first subparagraph, includes any conduct on the part of the government by which financial resources are made available to the recipient.
Council, can I just stop you there? I mean, this land is located in Tatooine, and yet the allegation is that it's Alderaan that has provided the subsidy. And when we look at the definition of a subsidy, we note that it's a financial contribution by a government or public body within the territory of a member. So how is it that you are alleging that it's Alderaan that has provided the subsidy?
Madam Panelist, it is our contention that in order for there to be a subsidy under the first subparagraph of Article 1.1 of the ASCM, we have to have 3 elements. There must be a financial contribution, a public body, and a benefit. And it is our contention that the reference to within the territory of a member refers to the term public body or government and not to the financial contribution itself, as has been held by the panel in U.S. anti-dumping and countervailing duties China in paragraph.
Excuse me, Counsel, if I can interrupt you. I have a quick question. If you say that the terms within the territory of a member only qualifies government or any public body, could you give me an example of a situation where a government or a public body is not within the territory of a member?
Mr. Panelist, it is our contention that indeed the government or public body must be within the territory of the member in order for there to be a financial subsidy.
Would there be a situation where a public body is not within the territory of a member? In other words, what is the use of the terms within the territory of a member? Because any government or any public body will, in my opinion, always be in the territory of a member. It can't be somewhere else. So could you give us an example where that would not be the case?
Mr. Panelist, in the present case, it is not our contention that such constellations would exist. And it is a fact that Investrix is located and established in Alderan, and therefore it is not relevant for the present case whether or not Investrix could be located outside the territory of Alderan, and whether it then still would fulfill the requirements of a subsidy. Madam Chair, distinguished panelists, turning to the
But counsel,
second.
again, your argument is that it is the land that is the financial contribution. You're saying the land equals a good, equals a financial contribution under the definition of a subsidy, but the land is not located in Alderan. So I'm asking sort of in the same line as my colleague, how is that then within the territory of the member that is conferring the benefit, or is that is providing the financial contribution?
Madam Panelist, it is our contention that the reference within the territory of a member does not relate to the financial contribution, and that the financial contribution itself can indeed cross borders. And let me illustrate this with an example, Madam Chair, distinguished panelists. Such cross-border provisions must fall within the scope of Article 1 and 3.1a ASCM, otherwise this would prevent international trade. Let me illustrate this with a specific example. Imagine we have country A and country B. The two countries conclude an agreement. Country A provides a subsidy to an exporter, in country B, and country B provides a subsidy to an exporter in country A. If one was to exclude such cross-border constellations from the scope of the Acm agreement, such agreements would not be objectionable, and countries would be free to subsidize their exporters by way of agreements with other countries. Madam Chair, distinguished panelists, let me turn to my government's
Excuse me, Councillor, but we're not free to interpret the Acm agreement the way we want, just to address any possible problems in the world. So just to address that situation that you have said, what support do we have in the Acm agreement to support that argument, bearing in mind how we need to interpret the agreement?
Madam Chair, when we look at the scope of the agreement, there's nothing that would prevent such cross-border constellations in the scope of Article 1, as we have laid out. Within the territory requirement merely refers to the public body or a government, and as long as this entity is within the territory, the financial contribution can go to other countries. And furthermore, for the purpose of Article 3.1a ASCM, we see no territorial limitations on the scope in the agreement itself.
Excuse me, Counsel. You say that a financial contribution can be granted to an entity which is outside the territory of the subsidizing country. Do you have any example of such situation which would be different from our situation? Maybe in the Acm agreement, there is some situations that are similar, or in past WTO case law, there has been cases which have discussed situation of a financial contribution being granted to an entity outside the territory of the subsidizing member that you could give us as an example.
Mr. Panelist, we are unaware of such a specific constellation in case law. However, the jurisprudence by the appellate body and the panelists has never specifically excluded cross-border subsidies from the scope. There's no such finding by either the appellate body or the panel. And let me turn to our second submission.
Sorry, if I could just have one more question. You ask us to look at the text of Article 1.1 for the purposes of interpreting within the territory, but is there any context found in other parts of the Acm agreement that support your interpretation?
Madam Panelist, while there are other references to the territory of member states in other provisions of the Acm agreement, it is our contention that this bears no guidance to the scope of the agreement. For instance, footnote 63 only refers to a specific constellation of actionable subsidies for the total ad valorem subsidization of certain producers. And Madam Chair, distinguished panelists.
Counsel, since we all seem to be interested in this issue, let me ask you, what is the possible relevance of Article 2 to the discussion that we now have?
Mr. Panelist, Article 2 can certainly be used as a point of reference for the purposes of Article 1. However, it is our contention, looking at Article 2.3, that any subsidy falling under the provisions of Article 3 shall be deemed to be specific. Therefore, any reference to territorial or jurisdictional limitations within Article 2 cannot be applicable for the whole Acm agreement and for the scope of the very agreement if there's no such reference to jurisdiction or territory within Article 3.1a Acm.
Excuse me, Counsel, if I can build on my co-panelist's question, what do you do of Article 25.2, which clearly refers that a member shall litify any subsidy, blah, 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 granted or maintained within their territories? Shouldn't we use this to interpret Article 1 as well to understand that there is a territorial limitation?
Mr. Panelist, even if Article 25.2 relates to the territory of a member, it is the position of my government that the members at the time of the conclusion of the Acm could not have anticipated the substantial increase in cross-border subsidies in recent years. And it is furthermore our submission that Investorix just cannot constitute a public, but that Investorix constitutes a public body within the meaning of Article 1.1a1 ASCM. First, let us clarify the legal standard. A public body is defined as an entity that possesses, exercises, or is vested with governmental authority. Relevant evidence for these characteristics includes government ownership and the exercise of meaningful control over the entity, as well as the de facto exercise of governmental functions by the entity. Furthermore, the relationship of the entity with the government is a crucial factor in this analysis. And in the present case, distinguished members of the panel, the entity making the financial contribution is Investorix.
Excuse me, Counsel. So you explain to us what is the legal test to know what a public body is. Are we bound to follow this legal test, or if we disagree with it, can we reinterpret the terms public body?
Mr. Panelist, it is our contention that previous case law should be followed by the panel. In the present case, the interpretations of a public body in US Carbon Steel India and US Anti-Dumping and Countervailing Duties China, because there are no cogent reasons to deviate from the standard in the present case. And we would like to emphasize that Investorix is fully state-owned and was established by an Alderon ministry whose members form 80% of its board of directors. And furthermore, if I may draw the panel's attention to paragraph 10, line 8 of the case facts. Even though Investorix was reluctant to do so, it deviated from its standard commercial practice only after consultations with the government of Alderon. This shows meaningful control both on the shareholder and on the executive level. And Madam Chair, distinguished panelists, if this does not amount to meaningful control over an entity, what can?
Counsel, just to make it very clear, I thought I heard you say that the test is whether or not Investorix is exercising a governmental function. And now you have just gone to the issue of meaningful control. Are you suggesting they are one and the same, or is there some distinction? And if you are relying on governmental function, what is the governmental function that Investorix is performing?
Madam Panelist, may I be granted an extension of 2 minutes in order to answer? Madam Chair, excuse me.
Without objection, yes.
Thank you. Madam Panelist, Investorix exercises governmental authority in the present case. In accordance with the Memorandum of Understanding, Investorix has developed general infrastructure in the General and Special Development Zone and develops energy supply and connectivity construction in the zone. Madam Chair, distinguished panelists, those functions are emblematic for governmental authority. And furthermore, in the joint venture committee established by the Memorandum of Understanding, Investorix is vested with the same function as the Ministry of Investment of Tatooine. And finally, the relationship between Investorix and the government is a very close one. Alderon vested Investorix directly with rights and obligations, as well as governmental functions in the Memorandum of Understanding and interstate agreement. It is the third submission of my government that the provision of land confers a benefit to the recipient. In order to establish a benefit pursuant to Article 1.1b ASCM, the recipient must be made better off than it would have been in absence of the contribution. In the present case, Desertix purchased full ownership rights from Investorix. Investorix is the only supplier of land in the John Land Special Development Zone. If I may draw the panel's attention to paragraph 9, line 2 of the case facts, where it is stated that it is Investorix's standard commercial practice to sell land use rights only. Therefore, on the market, Desertix would have obtained only land use rights, which are limited in
But
time.
counsel, my understanding is that the land rights that have been provided were 75-year leases. So I'm just trying to understand why you're arguing that this is somehow materially different such that it provides a major benefit, that in this one instance, it was the sale of the land as opposed to a less expensive lease for 75 years. I mean, so you have one, a purchase price, and the other is a less expensive year lease for 75 years. Why is there necessarily a benefit? Why are you better off?
Madam panelists, let me illustrate this. Desertix is better off when comparing the prices for the two types of rights over the long term. After this minimum 75-year duration, as Madam panelist quite correctly points out, other enterprises will have paid $750 per square meter for land use rights. Desertix, on the contrary, will have paid only $215 per square meter for full ownership.
Counsel, when you do this calculation, don't you have to take into account that the fact that you're not paying this price instantly, you're paying it over a number of years. So is that really comparable to the current purchase price?
It is our contention, Mr. Panelist, that one should take into account that it is provided or paid rather for a long period of time. However, that difference between $750 and $215 cannot account for this. And in sum, even though covered under the veil of a cross-border transaction, the provision of land constitutes a subsidy falling on Article 1A SCM. I'll now proceed to the second.
Counsel, just to keep you on this point. So cannot this be used to reinvest? So if you're just paying per year, there must be some kind of discount rate. I don't see how you can just compare the one sum to the other, because you can make other use of that value in the meantime.
Mr. Panelist, I believe my time has elapsed, and my co-counsels will have to address your questions. Thank you.
Mr. Panelist, to quickly answer your question to my co-counsel, it is our submission that the fact that the purchasers of land use rights cannot even choose whether they purchase full ownership rights or land use rights, but the fact that full ownership rights and thus this benefit was only awarded to Desertix represents the benefit obtained by Desertix in the present case. We submit furthermore that the provision of land fulfills the requirement of export contingency according to Article 3.1a of the ASTM. In fact, Article 3.1a of the ASTM prohibits any subsidy contingent or conditional upon export performance. In Australia, Automotive Leather 2, the panel held that export contingency must be inferred from the total configuration of the facts.
Excuse me, may I ask a question about that on the export contingency? As I understand it, the language in the case note describes a shall endeavor. How does that amount to export contingency? What is that best efforts or is it a requirement?
Madam Chair, we submit that the wording shall endeavor fulfills the threshold for contingency under Article 3.1a of the ASTM, as the word shall used in the land sale contract represents the binding force of this clause in the land sale contract. Moreover, we submit that the fact that on the day following the negotiations, or excuse me, on the day following the negotiations of the land sale contract, the ambassador of Alderan to Tatooine stated in paragraph 10 of the case facts that despite difficult negotiations, Desertix had accepted to supply Alderan's windmill industry first, and this persistence of Alderan on the export of Saberlight PMGs shows that this was a binding commitment and that therefore
But this is a statement by a government official in a public relations type context. So I don't know to what extent that really is legally binding. And when you have a phrase like shall and then endeavor following immediately afterwards, doesn't that pose some contradiction? And to the extent that there is a contradiction, doesn't that diminish any type of requirement?
Madam Chair, first, as for what concerns the statement by the ambassador, the panel in Argentina import measures held that statements of government officials can serve as evidence to support, in dispute.
Yes, it can serve as evidence to support, but the initial requirement, one would look at the agreement itself, at the language, the requirements in the SCM itself to determine whether there is an issue here. So in other words, the statements by the ambassador modify the shall endeavor, but do they change the essence to make it shall, as you are arguing, versus endeavor?
Madam Chair, we submit that what illustrates as well that this clause was binding and that it reaches the threshold, for contingency, is the fact that this clause in the contract is not subject to tattooing laws and adjudication, but it is to be resolved, disputes relating to this clause must be resolved by the joint committee between Aldran and Tatooine, and this shows wherein Aldran has even further power to make sure that this clause is enforced and that Desertix follows its commitments made under
So,
this
Counsel,
clause.
are you contending that the subsidy is contingent in law on exportation?
Madam Panelist, no, we are submitting that it is contingent in fact upon export performance.
Excuse me? Really?
Yes,
Okay, all right. Because I was confused. I was about to ask the same question. What are you arguing? De jure contingency or de facto contingency? You argue de facto contingency. Well, try to link your argument now with the case law on de facto export contingency.
Mr. Panelist, de facto export contingency must be inferred from the total configurations of the fact. We are not dealing with the jure export contingency because this clause, this obligation was not contained in a law or a regulation, but was contained in the contract between the Desertix and Investorix. For this reason, we submit that the provision of land was contingent upon export performance, and that therefore the provision of land to the Desertix represents a prohibited subsidy within the meaning of Article 3.1 of the ASTM.
No, but you're not linking it to the case law that we have on de facto export contingency. Link it with what the appellate body said about de facto export contingency in the Airbus case.
Mr. Panelist, we submit that in addition to the clause, the fact that Desertix is a fully owned subsidiary of Special Electrics, which is a well-established market player on the worldwide PMG market, which established Desertix specifically to produce and export Saberlight PMGs, shows that there is de facto export contingency in the present case. Madam Chair.
Sorry, I just have a question on that. Where are the exports going?
Madam Panelist, the exports are going to Alderon.
To the subsidizing member?
Correct.
And is that the way we normally understand export contingency under the Acm Agreement? That a member subsidizes exports that go back to that member?
Madam Panelist, it is our contention that under the ASCM agreement, we do not have a geographical requirement on where the subsidy originates or where they're destined for, which is why we submit that the exports at hand fulfill the requirements of Article 3.1a of the ASTM. This leads me to my government's second submission.
Can I just ask quickly, Council, what would make this different than from a domestic subsidy, technically, since it's just going back into the market of the subsidizing country? It seems like export contingency is trying to capture something different from a domestic subsidy, which is not even clawed by the Acm agreement.
Mr. Panelist, would you mind rephrasing your question? I'm not sure I understood it to its entirety.
Sorry, it is
That is
clawed.
okay.
Sorry. Does this not just look like a non-export contingent subsidy? Because it is not actually being exported outside the country. And the reason we prohibit export contingent subsidies is because they're exporting, causing distortions potentially in other markets.
Mr. Panelist,
Just if I can add, your co-councillor before said the purpose of the Acm agreement is to discipline subsidies that distort international trade, correct? Could you please explain to us how this subsidy is distorting international trade? If the goods go back to the country that is actually providing the subsidy, just don't see that.
Madam Chair, distinguished panelists, we see, unfortunately, that the panel is not convinced by our argumentation on their export contingency. However, it is the position of my government that we, due to the fact that the ASEM agreement does not contain any geographical requirement as concerns the origin and the destination of the exports, this type of exports should also be encompassed by the ASEM agreement and by Article 3.1. This leads me to my government's second claim.
Before you escape, what is the possible relevance of Article 27, paragraph 2A of the SCM agreement to the argument that you're trying to develop?
Mr. Panelist, we submit that Article 27 does not apply or is not relevant in the present case, and it is contained in Part 8 of the agreement. This leads me to my government.
Excuse me, Council. The country that is receiving the subsidy here is a least developed countries, and those are not prevented from providing export subsidy, as my co-panelist was pointing out.
Mr. Panelist, the country that is providing the subsidy at hand is Algeria. Algeria is not a least developed country, which is why we submit that Article 27 is not relevant in the present case. Turning to my government's second claim, we submit that the loan by Zurich's bank constitute a specific subsidy within the meaning of Article 1 of the ASCM, and that it results in serious prejudice contrary to Article 5C, right, with Article 6.3C of the ASCM. I believe this panel will want to hear our stand on jurisdiction under Article 2.1 of the ASCM, which is why I will jump to that directly. Madam Chair, distinguished panelists, Algeria will most likely try to disguise and to dismiss our claim on the cross-border loan by submitting that the Zurich is not established in Algeria and that therefore the Zurich is supposedly not within Algeria's jurisdiction to dismiss our claim. Let me elaborate why we submit that this panel should not follow the argumentation of the respondent in this matter. Madam Chair, distinguished panelists, first, jurisdiction is ordinarily defined in the Oxford English Dictionary as power, authority, and control. Excuse me. We submit that we must interpret jurisdiction within the ASCM agreement, resorting to the VCLT, more specifically to Article 31 of the VCLT, as it has not yet been defined by case law. Jurisdiction, as I previously mentioned, is ordinarily defined in the Oxford English Dictionary as power, authority, or control. Second, as my co-counsel pointed out, the main object of the ASCM is to discipline subsidies which distort international trade. If by way of a foreign subsidiary, the ASCM could be circumvented, and international trade distorted, this would
Excuse me,
contradict.
Counsel. You said the purpose of the Acm Agreement. How are we supposed to know what the purpose of the Acm Agreement is? There's no preamble to it, so.
Mr. Panelist, it is true that there is no preamble to the ASCM agreement. However, the panel in U.S. export restraint stated that the object and purpose of the ASCM is to discipline subsidies that distort international trade. We submit that therefore jurisdiction must cover any form of authority over the recipient. In some
Counsel,
interpretation.
can I stop you there? Because if I'm looking at Article 2, it clearly says that this has to be within the jurisdiction of the granting authority. So help me understand, what is the jurisdiction and who are you saying is the granting authority? What is the jurisdiction of the granting authority of this law?
Madam Panelist, we submit that the granting authority in the present case is Alderon through Investorix, that Alderon has jurisdiction over the Zertix, as the Zertix forms, together with its parent company, Special Electrics, a group of enterprises within the meaning of Article 2.1 of
So
the
the granting
ASCM.
authority is Alderon and the recipient of the loan is located in Tatooine. How is it that you're saying that the grantor of the loan is within the jurisdiction of the, I mean, again, how is it that Desterex is within the jurisdiction of the granting authority?
Madam Panelist, we submit that Desertix is within Alderon's jurisdiction, as we must interpret jurisdiction in a way that permits us to give meaning and to interpret effectively the ASCM. In fact, Alderon has power and authority over the Zertix, which forms a group of enterprises together with its parent company, Special Electrics. In fact, the Zertix.
Excuse me, Counsel. So you say that Alderon has power and authority over the Zertix, a company incorporated in another country. So what kind of power could Alderon exercise over an entity which is not in its jurisdiction? Can it send the police? Can it enforce a court ruling against it?
Mr. Panelist, Alderon has power over the Zertix, as it can regulate the parent company, which is established in Alderon. But what is more, as my co-counsel has pointed out that my time is lapsing, may I be granted an extension of 2 minutes to conclude my submission?
Yes, without objection, yes.
Thank you. Returning to your question, we submit that in the present case, under the ASCM, we are not inquiring into whether a state has a right to prescribe and enforce rules over the entity that we are analyzing. We're looking at whether there is a sufficient connection between the entity that was granted the subsidy and the granting member that permits us to apply the ASCM to the constellation at issue.
Still clarification, what sufficient connection, if that connection is not territory, what is the connection? And secondly, are there any limitations to state jurisdiction over things that happen outside its territory under public international law, and is something we should care about for the present case?
Madam Panelist, of course, territory can be a link and a sufficient degree of authority between the granting member and the enterprise that was granted the subsidy. However, we submit that this is not the only relevant link to determine whether the granting member has jurisdiction over the entity that was granted the subsidy.
Sorry, could you just clarify, under international law, what are the bases for prescriptive jurisdiction?
Madam Chair, under public international law, a state, as was found in the Lotus case, a state has prescriptive jurisdiction, can have prescriptive jurisdiction over an entity where there's no prohibitive rule to the contrary. We submit that this, in the present case, Alderon has jurisdiction over the Zertix, as again, it has a relevant connection, one, over the parent company, Special Electrics, which is established in Alderan, and 2, over Investorix, which, as my co-counsel has pointed out, is a Alderan public body that exercises governmental functions within the Dunland Special Development Zone.
Wait, but you refer here to the Lotus judgment. You seem to say that a state always has jurisdiction, and unless there is a rule stating it has no jurisdiction. Is that your proposition or your reading of the Lotus judgment?
As for what concerns prescriptive jurisdiction, the position of my government is that, according to the Lotus case, one can have prescriptive, not enforcement jurisdiction where there's no prohibitive rule to the contrary. However, this is not what we submit. It is not the basis upon which we submit that Alderan has jurisdiction over the Zertics. We submit that Alderan has jurisdiction over the Zertics due to the connection, as I stated, via its parent company and by over Investorix, which is exercising authority in the Dunland Special Development Zone. Moving on to the second part of my government's claim, we submit that the loan resulted in serious prejudice to the interest of Corson. As first, it caused lost sales because Magnetics lost the sales from a 5-year contract for the exclusive supply of a large windmill manufacturer, and the sales were gained by the Zertics. There was a causal link between the loan and the lost sales, and the lost sales occurred in the same market as a subsidized product, namely the market for Saberlight PMGs.
Council, are they really the same market? I mean, if the decision is being made based on whether one is environmentally safer and better to use and produces more energy, I see that your time has expired, as opposed to, you know, again, one using neodymium, which has got a lot of environmental issues and is not as capable of producing wind power. How are those the same market?
Madam Chair, distinguished panelists, before addressing the third claim, let me address Madam Chair and Madam Panelists' concerns. To compete in the same market, 2 products must exercise competitive constraints on each other. They must be substitutable. And in the present case, neodymium and Saberlight PMGs create such competitive constraints on each other as they directly competed for the contract with Ventix Generatix. This also shows that the PMGs are substitutable from a consumer side perspective, and therefore the 2 types of PMGs compete in the same market. That is, the lost sales occur in the same market as the subsidizing
Are they
product.
substitutable from a supply perspective, and should we take that into account?
Madam Panelists, they are substitutable from a supply side perspective to a certain extent. However, we are aware of the fact that the raw material used for these 2 PMGs are different. And it is therefore that we submit to this panel that the consumer side substitutability overweighs in the present case and must be considered as a more reliable source to assess the market in the present case. It is for these reasons that I proceed with the third claim on behalf of my government. Alderan has not only disguised subsidies violating the ASCM, but it has also disguised quantitative restrictions violating the GATT. And this is why we submit that Alderan restricts exports of the rare earth element neodymium in violation of Article 11.1 GATT. I will elaborate on 2 submissions in this regard. First, that 3 of Alderan's instruments, that is the non-renewal of neodymium mining permits, the export tax, and the export registration requirement, constitute an overarching measure. Second, that this overarching measure has a limiting effect on exportation, inconsistent with Article 11.1 GATT. I will now
Council, can I just quickly, do all of these 3 measures have to contribute to the limiting effect for us to find that there exists an overarching measure with a limiting effect?
It is the submission of my government that this panel should differentiate between the analysis of the overarching measure according to the requirements as set forth by the appellate body in Argentina, import measures, and the limiting effect of the Article 11.1 GATT. However, one of these requirements the appellate body held is that there must be a interaction of these instruments and that they must have a common policy objective. So it is our submission that the common policy objective of these three components is to drastically limit neodymium mining exports to promote Alderon's own industry. And to illustrate this, may I draw the panel's attention to paragraph 18.
Excuse me, Counsel, just a quick question. So you said these measures all have the same aim of limiting exports. How are we supposed to know what the goal of the measure is? Do we just look at the statements made by the government? Do we look at the measures themselves? Is there a specific test we can use to know what the goals of the measures are?
It is our submission that this panel should make an objective assessment pursuant to Article 11 of the DSU, and it should take into consideration all the relevant evidence at hand. This includes the statements, but however, this also includes the data which my government will bring forward.
So picking up on what my colleague said, you responded that the analysis of the existence of the measure must be separate from the assessment under Article 11.1. But if we find that this measure, as you describe it, exists, does it then not automatically follow that there is a violation of Article 11.1?
If, as we argue in the present case, the common policy objective is to drastically limit neodymium, this is the case because the common policy objective my government brings forward is directly a violation of Article 11.1 GATT as it limits the exportation. However, we submit to this panel that overarching measures can be found in other instances and that the standard test as set forth by the appellate body can be fulfilled if there is another objective, another policy objective, which then this panel might find not to be a violation of Article 11.1 GATT.
And Counsel, if we were to disagree with you and find that there is no overarching measure, we recognize that there are these three separate elements, but we were not to find that they constitute an overarching measure, what becomes of your claim?
It is the submission of my government that in that present case, this panel would still have jurisdiction over the present case. And indeed, in Argentina import measures, the appellate body held that the panel request pursuant to Article 6.2 of the DSU.
But counsel. Of course, this panel will look at the measures that you put before us. But are you arguing that the export duty can possibly be an export restriction within the meaning of Article 11? That's a yes or no.
Then our short answer would be no. In the case this panel finds there not to be an overall.
That's fine. Then the closing of the mines, which seems to me as a very, very internal measure. Can such an internal measure fall within the scope of application of Article 11? Which, in the opinion of many, would be something that you do at the border. Article 11 addresses border restrictions.
My government submits that this would also be the case because we assert that Alderon's measures systematically restrict exportation. And this is also the case for the non-renewal of mining permits. And this is the case because we submit that this panel should look at the effects of the measures at issue. The appellate body pointed out in China raw materials that the effect of the measure at issue must be limiting. And the panel in Argentina hides and leathers added that the measure at issue must, and I quote, cause a low level of exports to contribute to it, unquote. What is essential here is that this panel look at the word cause and that it establish a causation between the measures the respondent has enacted and the limiting effect under Article 11.1 of the GATT. Furthermore, it is our submission that all the other requirements of the standard.
Excuse me, Counsel, if I can build up on my colleague's question. So assuming we find that there's no overarching measures, and then we say that the export tax does not violate Article 11, whether or not we can look at it. Is there any other article of the WTO agreement that you could have used to bring a complaint in this case against these measures?
We have not brought forward any such argument. However, we would reserve the right to file a complaint either under the most favored nation principle or national treatment. There might also be the schedule of concessions which is applicable. However, we are currently unable to provide any further information, and this does not fall under this panel's jurisdiction and the scope of jurisdiction of this
Council, just backing up from this just a bit, you referenced the public statements that Alderaan had made in undertaking these restraints. So what Alderaan is describing is that it's undertaking these efforts because of an environmental hazard. It's seeking to prevent the proliferation of this environmental hazard. Don't WTO rules permit a government to take that action? And what's so striking here is that because Alderaan really has cornered the market on this particular mineral, it's really giving up a tremendous commercial advantage. Doesn't that show that it really is serious about the environmental concerns?
We would disagree respectfully, Madam Chair, with the characterization that Alderaan gives up on commercial opportunities. To the contrary, it is the submission of my government that Alderaan deprives PMG producers worldwide of their key input material. And by doing so, Alderaan seeks to give its own PMG industry, which this panel should note uses Kyber instead of neodymium, a competitive edge on the world market. So it is the case that under WTO law, the protection of the health and life of humans, animals, and plants, for example, is a justification. However, this is not what Alderaan's goals are in the present case. And if Alderaan truly wanted to protect its environment, it would not adopt instruments which selectively target exports, but rather it would focus on the mining of neodymium in the first place. It would probably have to ban neodymium mining completely and consistently.
Council, can I stop you there? Because you've talked about this causal link between these measures and exports. And yet when I look at the data, it's pretty clear that domestic sales of neodymium fell in sort of roughly the same percentage decline as export sales. So how is it that we think there's a direct causal link between exports and these measures when domestic sales suffered in a similar vein?
Madam panelist is right. There has been a decline in domestic sales of the raw material. However, it is under this title that we submit to this panel that a violation of Article 11.1 is still the case at hand, as the domestic production is just, the reduction in domestic production is just a side effect of the export restrictive measures. And we would like to underline this by citing and by showing how these measures are interdependent, because the non-renewal of the mining permits reduces the number of active mining firms that are active in Alderaan, and thus also the quantity of neodymium available for exports in itself. This would not effectively prevent the remaining mining firms from exporting. And this is exactly, Madam Chair, distinguished panelists, why Alderaan introduced the export tax of 25%, which renders neodymium export sales less profitable than domestic sales. And it also ensures that neodymium is mainly sold domestically. In turn, the export tax depends on the non-renewal reducing the mining activity, and this is the case so that the neodymium still extracted is absorbed by the Alderaan market alone. And then again, the export registration.
Sorry, Councillor, could we look together at Annex 6 and give me exact numbers to support your argument that most of the neodymium production is sold domestically rather than exported in year 2020 in particular?
May I be granted, Madam Chair, an additional 2 minutes to answer Madam Panelist's question?
Yes, Council, you may.
If Madam Panelist refers to the year 2020, it is our submission that at the moment, I am unable to provide you with a substantive comparison of the data. However, we would make the necessary calculations and provide this panel with the necessary calculations if that is possible. All in all,
Excuse me, Council, if I can follow up with another question. So you are claiming that there's a systematic prohibition of export. However, when we look at the non-renewal of the mining permits, we see that some mines are still operating. And looking at past WTO case law on the issue of what is a measure that is systematic, we see that it needs to be in the majority of cases. However, here, when we still have a substantial number of mines which are extracting and they're selling both domestically on export. So how do you demonstrate to us that there is a systematic element to the measure you are trying to demonstrate?
it is the position of my government that the systematic nature of the present measure must be established, taking into consideration the three instruments which my government brings forward. So the sole fact that one of these instruments only targets part of the miners in that country, in Alderan, does not mean that the three instruments cannot interact systematically. And it is relevant for you, Mr. Panelist, to point out to that fact that there are still mining firms active in Alderan, mining firms which are still emitting dust and toxic waste. So it is not credible if the complainant, if the respondent, pardon me, brings forward any argument regarding the protection of its people, because it has not taken all the necessary measures. And I will now conclude our submission in that respect. As a consequence of Alderan's trade distortive conduct, Khorasan's economy is in a critical state. Alderan heavily subsidizes its domestic PMG industry and deprives our PMG industry of its key input material. While Alderan tries to disguise these measures, we hope that this panel will see through Alderan's veil and take action against its unfair conduct. Therefore, and in light of the arguments brought forward by the government of Khorasan, we respectfully request this panel to find that, first, the provision of land is contingent upon export performance, contrary to Article 31A ASCM. Second, the loan causes serious prejudice to the interests of Khorasan, contrary to Articles 5C and 63C of the ASCM. And third, the three instruments on neodymium constitute an overarching measure that systematically restricts exports.
Thank you, counsel. At this point, I'm assuming we are ready to proceed now to the respondents. And I would invite you to begin your presentation. Thank you.
Good afternoon, Madam Chair, members of the panel, and representatives of Khorasan. My name is Hanna Minere, and I'll be responding to the claim regarding the provision of land under the Acm Agreement in the following 12 minutes. The world is at a crossroads between its polluting past and its sustainable future. Wind energy is one of the most important tools to transition to green energy. Therefore, we should not look with suspicion upon WTO members and their private companies who've made great innovations to the worldwide production of green energy. And we must recognize that these innovations were not the result of subsidies granted by Alderan, but of hard work and ingenuity of the market forces. Alderan's own road to sustainability has led it to take the necessary measures to protect its environment while not losing sight of the health of its population. Alderan wants to be a place where sustainable green
Excuse me, counsel. It seems that you are leading with the policy argument that everything is fair game because of the purpose here that for environmental protection. You correctly point to the value of green energy, but does that justify any of the measures taken, or are you going to address the response, the comments by the complainants, the arguments by the complainants?
Thank you for that question. We are, of course, aware that policy objectives are not included in the SCM agreements. However, we want the panel to be aware of the policy objectives, as that is, for example, very important for our analysis under Article 20 of the GATT, as my co-counsel, Ms. Franse, will explain. But we want to make
Excuse
sure.
me, Counsel, are you arguing that Article 20 of the GATT can justify a violation of the SCM agreement?
No, Article 20 of the GATT agreement can justify a violation of the GATT agreement, but not under the SCM agreements. However,
Only the GATT agreement?
Not only the GATT agreement, but in this case, we're only arguing under the GATT agreements and the SCM agreement. So therefore, in this case, only under the GATT agreements.
Would you happen to clarify which other agreements, violations of other agreements may be justified by Article 20?
May I come back to you on that question?
You may.
So we want the panel to be aware that that's in Alderaan, the protection of the health of our citizens and the environment are key priorities, but we also want to ensure a prompt compliance with WTO obligations. I will first bring forward the position of the government of Alderaan that the provision of land is not a subsidy in Article 1 of the SCM agreement, and in the alternative, that it is not a prohibited subsidy in Article 3.1 of the SCM agreement. I will start with my first argument that the provision of land is not a subsidy in Article 1 of the SCM agreement. I would first like to respond to the arguments of the complainants about the transnational subsidies. As Article 1.1 of the SCM agreement states that a financial contribution must be granted within the territory of the SCM agreement. As there is no definition of within the territory in the SCM agreement, this term needs to be interpreted in accordance with the customary rules of treaty interpretation following Article 3.2 of the DSU.
Yes, but I think they say that those terms qualify only government, not the financial contribution itself. So if you can address that point.
Of course. Well, that is the interpretation of the complainant. However, there has never been an interpretation established by the panel, nor the appellate body or the SCM agreements. So therefore, we have to find recourse to the principles of treaty interpretation, which we can find in Article 3.2 of the DSU. And when we look at the interpretation of Article 3.2 of the DSU, which, for example, refers—
Are you saying that if there was a panel report or appellate body report, we wouldn't have to interpret the term territory in Article 1.1?
Well, we know from the jurisprudence, and for example, US Stainless Steel Mexico, that appellate body reports have a de facto binding precedent unless there are cogent reasons to diverge from the appellate body reports. But in this case, there are no appellate body nor panel reports.
So, what are cogent reasons?
Well, these were, for example, established in US anti-dumping countervailing duties China, and that can, for example, be the case when an authoritative interpretation has been established, or, for example, when we see that the interpretation is unworkable. But those cogent reasons are not established in this case, as there is not even an appellate body nor panel report. So in this case, we need to look at the general rule of treaty interpretation, which is Article 31 of the VCLT. And this states that the term needs to be interpreted in accordance with its ordinary meaning in their context in light of its object and purpose. The ordinary meaning of within is described by the Oxford Dictionary as inside. And the ordinary meaning of territory is defined as a particular land or area of land. So the ordinary meaning of within the territory can be described as inside a particular land or area of land. And regarding the context of Article 1 of the SCM agreement,
again, we're talking about within a land. That's clear. That's the ordinary meaning. But what? The government or the financial contribution? What needs to be within that land?
It is our submission that the recipients of the financial contribution must be established within the territory of the granting authority.
How do you support that argument?
Well, when we look, for example, at the context of Article 1 of the SCM agreement, we can refer to Article 2.1 of the SCM agreement that states that a subsidy is specific if it is granted to enterprises within the jurisdiction of the granting authority. And as my co-counsel, Ms. Ons, will explain, within the jurisdiction also needs to be interpreted as being territorial. Moreover, Article 25, paragraph—
I understood that the complainant said that we could not look at Article 2 as context for interpreting Article 1.1. Could you respond to that argument, please?
Of course. Well, we can look at Article 2 for the context, as we know from the negotiating history of Article 2 of the SCM agreements, that in the initial draft it stated within the territory of the subsidizing member. It was only after the negotiating round that it was changed to within the jurisdiction of the granting authority. So therefore, we can look as a context to Article 2 of the SCM agreements.
I'm a bit confused. Did you, like 2 or 3 minutes ago, did you come to a conclusion on the ordinary meaning? And did you then move to context?
Indeed.
You did that?
Indeed.
You think that that is a proper application of Article 31(1)
So we
of the
first,
Vienna Convention?
thank you for that question. Well, we first need to look at the ordinary meaning in their context in light of its object and purpose. So as we've established the ordinary meaning of within the territory as inside a particular land or area of lands, we can then look at the context of Article 1 of the SCM agreements, and we can refer to, for example, Article 2 of the SCM agreements.
Well, you've got one panelist that disagrees with your approach, but
Moreover, Article 25, paragraph 2 of the SCM agreement states that a subsidy that is granted or maintained within the territories of the members must be notified. So, and their territories is described as an ordinary meaning, in a possessive form of they.
Excuse me, Council. So you say that the definition of a subsidy itself already has a territorial requirement. Is that correct, right? So then if you read Article 25(2), why is there a need to then reaffirm that you only notify the subsidies granted or maintained within their territory? Then if we follow your approach, these terms are redundant because in the concept of subsidy, there's already a territorial limitation.
Thank you for that question. Well, Article 25.2 refers to both specificity and within the territory, and because they have to be established separately under the SCM agreements, as for example, a prohibited subsidy is deemed to be specific, that means that they have to be analyzed separately. That means that Article 25.2 states that just confirms that we have to analyze them separately and that both conditions have to be established before there needs to be a notification.
Okay, so if I can follow up. So you say that the financial contribution and the government both have to be in the same territory, but the SCM agreement itself gives the example of export buyer's credit, which is a situation where the government gives money to a buyer which is in a third country. So wouldn't that be an internal contradiction with the SCM agreement where you would have Article 1, which would not consider as a subsidy something that is given as an example in the SCM agreement?
Thank you for that question. However, export credit support is a very different situation, as in that case, they aim to improve the financial package that national exporters can give to foreign buyers to actually improve the chances of those exporters to secure a contract. And the export credit support was, during the negotiations, explicitly included in the SCM agreements, as we know that they were, for example, included in the subsidies code, because they are seen as so trade distortive.
But excuse me, Council, are you not mixing up the financial contribution element here, which is indeed, as you say, given to an entity abroad, and the benefit element, which is then indeed for the entity that produced the goods which are then purchased? But you were telling us that the financial contribution has to be in the same country as the country that gives the subsidy. So that doesn't really answer my concern here.
Well, I will first clarify that our submission is that the recipients must be located within the territory of the subsidizing member. However, export credit support is indeed a case where financial contribution is granted to a foreign buyer. However, the export credit supports were explicitly included in the negotiations of the SCM agreements. And in this case, transnational subsidies were not included in the negotiations of the SCM agreements. And if we would in this case agree that transnational subsidies would be included in the SCM agreements.
Council, again on interpretation, did I hear you refer to the negotiating history?
Well, I'm referring to the negotiating history to support my arguments. However, I am aware that Article 32 of the Vienna Convention.
Which negotiating history? Where do you find the negotiating history? Whose history?
Well, the negotiating history of the subsidies code on the one hand, and also the negotiating history of the SCM agreements. And we can use that as supplementary means of interpretation under Article 32 of the Vienna Convention.
Do what?
only to confirm our interpretation. However, we also have to look at the object and purpose of the Acm Agreement. But before I move on to my arguments, may I ask for a 2-minute time extension?
Yes, thank you, Council.
So the only thing that I want to establish is that the export credit support was addressed during the negotiations of the Acm Agreement, whereas the transnational subsidies were not included. And the WTO expert group on trade financing has stated.
Council, my question really was, you referred to negotiating history. Which documents are you then referring to?
We are, for example, referring to the documentation of Gary Hurley, who was one of the negotiators of the Acm Agreements.
Well, he was one of the negotiators, yes, with his own memory and his own positions. Does that make it negotiating history within the meaning of Article 32 of the Vienna Convention?
I'm sorry, could you briefly repeat your question?
Oh, I think we're ready to move on.
Okay, so regarding the object and the purpose of the Acm Agreement, as was stated by the WTO expert group on trade financing, was concluded to address situations in which a government subsidizes its own domestic goods. So therefore, the financial contribution is granted within the territory of a WTO member when the recipient is located within the territory of the subsidizing member. And in this case, it is Investerix who grants the provision of land to Desertix.
Council, a question about this. It seems to me that a very narrow reading of this requirement of within the territory could lead to circumvention, that parties could structure, a country could structure its subsidies in a way so that the subsidy is awarded outside of the jurisdiction and therefore outside of the jurisdiction of the Acm Agreement. Could you respond to that, please?
Yes, indeed. However, regarding your question, we know that the transnational subsidies were not included in the Acm Agreements. If we would allow the Acm Agreement to be interpreted in that way, then transnational subsidies would be included in the Acm Agreements. That would mean that we would go against Article 3.2 of the DSU, which states that we cannot add or diminish the rights of WTO members under the covered agreements. So therefore, that would go against that principle.
So avoiding circumvention is adding to the rights and obligations?
No, in this case, it would not be a circumvention of the Acm Agreement, as it's just not included in the Acm Agreements. And to include it in the Acm Agreements, we would have to go back to the member states for renegotiations. But as my time is running out,
wasn't the question about circumvention, about the effectiveness? Oh, sorry, time is up.
Distinguished members of the panel, Honorable Chair, good afternoon. My name is Charlotte Ons. However, before commencing with my own pleadings about the loan granted by Zurich's Bank, I will briefly conclude the pleadings of my co-counsel, Ms. Mignola, about the provision of land. So, the provision of land is not a subsidy because it does also not confer a benefit. In contrast to what complainants submit, there was no benefit conferred to the respondent because the differences in price between the Joint and Special Development Zone and the Mos Eisley Zone are discussed because are normal because of the differences in geographical location and the additional cost that there is to provide safety within a zone that is prone to incessionist fights. Moreover, the fact that they use the long-term interest. I can see.
Yeah, you need to
Council,
turn off one of your mics, otherwise.
Yes, there are two mics on.
Otherwise, we can't use ours. Thank you. So you're referring to prices in a different industrial zone. Why don't you compare? Why don't you use as the benchmark the price in the same industrial zone, which was what the complainant did? They provided us with a benchmark, which was the land in the same zone, to argue that there was a benefit. Why are you looking at a different part of the country?
As they both submitted a Mos Eisley Zone and a benchmark in the same in the Joint and Special Development Zone, it is so that the long-term interest rates, the benchmark therefore that they submitted, did not take into account the land, the value of land over time. Moreover, the benchmark should be the private prices for some similar goods, as we know from US softwood lumber 7. So therefore, the loan did not, the provision of land did not confer a benefit. Moreover, the steps, in contrast to what complainants submit, the subsidy is not contingent, in fact, upon the exportation of Sableye PMGs. Because as indicated by Madam the panelists, Article 4 states shall endeavor. From Canada Aircraft, we know that we must take into account the entire contract to interpret the provision as such. And moreover, from Korea radionuclides, we know that the term after the word should or
Excuse
shall.
me, Councillor, just to clarify, do you agree that we are talking about a de facto contingency claim here as they submitted?
Yes, I indeed agree that they were that it was submitted that there was a de facto contingency claim, but there is none in this case. Also, to address the question posed by Professor Van den Bossen that about the case law in Canada aircraft, the difference between evidence of de jure and de facto contingency.
Council, you want to correct that? Canada aircraft?
You refer to the appellate body in Canada aircraft in paragraph 176. Sorry, 167.
You may want to check that, but
so, well, could you please repeat your question?
I say that if I understand correctly, they pleaded there is a de facto contingency, export contingency claim. Do you agree that we are talking about a de facto contingency claim?
Well,
rather than de jure? That's my question.
Well, the complainant can only rely upon the contract, and the euro should be the wording of the relevant legislation, as here there is no legislation at hand, but only a land sale contract. Therefore, it has to be a de facto contingency if there was found by the panel to be one. However, it is our submission that the subsidy is not contingent upon the fact of the land sale contract, as these verdicts must only endeavor the export of Sableye PMGs, but they are not sanctioned if they do not comply with these provisions. Moreover, the high level of expectation of Sableye PMGs only reflect the conditions of sale and demand in the export market of the PMGs.
But Council, if we are in the world of a contingency de facto, why is the terms, the legal language of the sales contract relevant for a de facto analysis?
The terms of the contract may indicate a specific link to an anticipated exportation. However, here, as we know from Australia Automotive Letter 2. However, here, this paragraph is not a commercial obligation for these certificates to export. Therefore, we submit that the provision of land granted by the certic by Investerix is not a subsidy, and that it is not a prohibited export subsidy, as it is not contingent upon the exportation of Sableye PMGs. So, proceeding to the second claim regarding the existence of a specific subsidy as per Article 2.1. The claimant submits that this loan granted by Zurich Bank is a specific subsidy as per Article 1 and Article 2 of the Acm Agreement that violates the Acm Agreement. Moreover, the complainant submits that the loan caused serious prejudice to the interests of Coruscant. First, the complainant failed to establish that the loan was indeed a subsidy. A subsidy is a financial contribution that grants a benefit within by a government or a public body within the territory that confers a benefit. First, it was not granted by a government or a financial contribution. It was not granted by a government or a public body. Moreover, it was not granted within the territory of a member, as this only refers to the location of the within the territory. Only refers
Council,
to the.
as I heard it, complainants are arguing that this is in fact a public body, in part based on the criteria of the ownership and control, but also in part because this idea of providing infrastructure development and land development and energy with, provisions of energy grids and everything else within a particular parcel of land is indeed a governmental function as it has been defined by the appellate body. And I'm trying to understand what is your response to that.
I am so sorry to correct you on that, Madam Pellenlis, but the claimant was arguing that Investorix is a public body that grants the provision of land. However, Desertix is not a public body as it is fully privately owned. And and Zurich's Bank is also my apologies. Zurich's Bank is fully privately owned and is the one providing the loan to Desertix. So therefore, claimant did not submit that Zurich's Bank is a public body. It is it was not granted within the territory because the recipient, this only refers to the situation when the recipient is located within the territory of the subsidizing member, which is not the case here as Desertix is located within Tatooine, so not within the territory of Alderaan.
Sure,
Moreover,
but they reject that there is such a territorial limitation to jurisdiction. So could you please address their arguments on that point?
Yes, claimant indeed submitted that the loan was to be de facto specific as per Article 2.1 of the Acm Agreement to Desertix. However, first of all, the loan is not a subsidy. However, if the panel would find it to be a subsidy, it was not granted de facto specific to Desertix, as granting the loans is a standard commercial practice of banks. Moreover, it must be granted within the jurisdiction of the granting authority. It must,
Yes,
so it had to be
and
granted.
I don't think you answer my question on the jurisdiction point.
I was still getting to it. I'm so sorry. So jurisdiction is to be seen as territorial jurisdiction because it is defined by the Oxford Dictionary as the extent or range or judicial or administrative power, territory over which such power
refer to the
extends.
Oxford Dictionary. Is there any rules in the WTO agreement that say we have to look at the Oxford Dictionary?
As my co-counsel already explained, territory and jurisdiction were not defined in the Acm Agreement, so we have to refer to the customary rules of treaty interpretation, such as because of Article 3.2 of the DSU, customary rules of treaty interpretation, such as Article 31. And from EC Chicken Cuts, we know that we can use the Oxford Dictionary to interpret these terms. So the extent or range or judicial or administrative power, the territory over which such power extends. This indicates a territorial view of jurisdiction, which was confirmed.
When is it possible for a state to exercise jurisdiction outside of its territory and where there is no other jurisdictional basis or ground like nationality that's being used? What would you need to exercise jurisdiction outside your territory?
From the Lotus case, we know that for there to be extraterritorial jurisdiction, there must be a permissive rule that confers authorization to exercise your jurisdiction there. However, in this case, there was no such permissive rule, and as claimant failed to establish.
Is the Memorandum of Understanding a legal basis whereby one party has accepted that another party exercises jurisdiction over its territory?
It is indeed so that a memorandum of understanding can be seen as a permissive rule. However, therefore, it has to be binding. A memorandum of understanding fluctuates between a gray area of mere political statements and a treaty. However, here, the memorandum of understanding is not binding upon the parties, from among others, and therefore it does not confer any authorization to exercise its jurisdiction.
You said that the memorandum of understanding is non-binding. What is your basis to say that it is not binding? Because to me, it seems to have some legal obligations in it. So can you please clarify your statement?
Well, from cases such as Somalia versus Kenya and Qatar Bahrain by the ICJ, we know that for a memorandum of understanding to be binding, it has to be the party's intent to be binding. Moreover, it must be signed by the ministers and it must be registered with the United Nations.
But is registration with the United Nations and signature a requirement for there to be a treaty?
No, but we know from the case law of Kenya versus Somalia that this is one of the indications of a memorandum of understanding to be binding. Moreover,
and what is the significance within the memorandum of commitments such as the parties agree to do things, the government shall create? I mean, throughout this memorandum of understanding are words to that effect. The parties will provide. These are not conditional terms that are used throughout this memorandum of understanding. So why is it not binding?
Well, there is also a lot of counter indications in the language, as for example, Article 10 says, through amicable consultations, and the preamble refers to the friendship between two governments. Moreover, the fact
Thank
that
you, Council, but that seems to relate to how disputes are resolved, not about the legal value of the document we are talking about here. So could you make the difference between the legal obligation that it creates and how those could be enforced? Yes.
apart from the fact that there is language that contradicts the fact that it would be binding, it is also the ministers that signed memorandum of understanding are not authorized to bind their states, as they are ministers of commerce and ministers of investments. We know that only heads of states, heads of governments, or ministers of foreign affairs of other ministers, after explicit authorization by their states, can bind their states in a memorandum of understanding.
How do we know they
the
lack?
significance of Article 11 then of the MOU? Any dispute shall be subject to Tetuan law and adjudicated before those courts. That seems to me to be pretty legally binding.
Well, it is.
And then I would further note with respect to Article 10, there are plenty of examples in WTO agreements in the DSU, for example, where parties are to attempt to resolve matters through consultations.
Well,
but they're certainly binding.
Well, Madam Chair, if the panel would find the memorandum of understanding to be binding, it is still so that here in this memorandum of understanding, in this case, there was no authorization conferred. So this means that Alderaan still does not have jurisdiction over Tatooine. So it is not, if the loan was granted to an entity located in Tatooine, it was still not granted.
Could you point me to the exact paragraphs in the fact of the case where it says that these two ministers did not have authorization to bind their respective states to sign this memorandum?
Well, in Article 12, we find the two people who have signed the memorandum of understanding. However, in the case facts, there is no authorization given. There is no explicit authorization given to the
So you're saying there's no authorization because there's no explicit authorization.
well,
That's it,
we
right?
have no indications that there was an authorization given. So as long as we don't have this, we cannot make assumptions that they were granted by their governments.
Okay.
So, moreover, the complainant also established that there was an existence of a permissive rule due to the nationality of the mother company of these architects. However, from the Barcelona traction case, we know that the state jurisdiction is the same as a company where the state is incorporated. And there are no reasons
Council,
to view these.
it's fairly commonplace to hold states that have jurisdiction overseas over the operations of multinational corporations that are headquartered in their territory. I mean, this is, again, very common for many purposes, registration requirements, taxation requirements, and many other things, where the home country, the jurisdiction of a multinational corporation, those governments have some degree of jurisdiction over the overseas operations. Why is this so different?
I just rephrase the question of my co-panelists. Why is all these instances in international law where you have this extension not relevant in the present case? According to you, I mean, I guess that's what you're trying to plead, that it's not relevant. Here is different. Why is that?
Well, it is different because here we must here, there is no jurisdiction confirmed by a permissive rule, and the mere fact that there is a mother company that is there is a mother company over these architects, which is based in Alderaan, does not indicate that there is jurisdiction of Alderaan in the Johnson Special Development Zone. There is no reason to view these two separate companies together, because it also states in the case facts that, for example, however, before I continue, might I request a 2-minute time extension?
Yes,
So
thank you.
it is also stated in the case, in the clarification questions, if I'm not mistaken, that these articles mother company, Special Electrics, would not even stand in for them for the loan that they granted. So if they do not even provide a guarantee for them when they receive a loan, why would there be a reason to look at these two separate It's the companies together.
Council, just a quick question on this. Does jurisdiction has to be exclusive, or could we find that it's concurrent, specifically within the meaning of Article 2 of the Acm Agreement?
Are you referring to joint jurisdiction?
I'm referring to whether in this case, there is anything that could help us find that, for example, two government could have jurisdiction at the same time, such as joint jurisdiction, yes.
Well, there are indeed instances where joint jurisdiction is accepted. However, then there still has to be a permissive rule to authorize such a joint jurisdiction, which in this case is absent. Therefore, there is no joint jurisdiction over the Joint and Special Development Zone, because it's only under the jurisdiction of Tatooine. So, moreover, if to proceed to the argument under the serious prejudice as per Article 5C and 6.3C of the Acm Agreement, the complainant failed to establish the existence of a causal link between alleged subsidy and its alleged market effects, the loss of sales. So, first, there must be there is a causal link only when there are no other factors that can constitute that there are no other factors that can contribute to the causality of this. Here we see that Sabolite PMGs are based while using a sustainable, non-harmful material. So there are other components, such as a global shift towards the use of sustainable material, that can that show that there is no causal link between
Excuse me,
subsidy
Council,
and
the fact that your company had to lower its price to match the price of the competitor, shouldn't that show that actually that is the reason? It's because of the price and the subsidy, and therefore they're in competition.
Well, commercial reasonableness is not an indication for a causal link. So it is it's also a very big supply contract of 5 years. So the number of PMG involved will likely be very high. So it is logical that there can be given a lower price for this amount of PMGs over a time. However, as I see that my time has elapsed, my co-counsel will briefly conclude my submissions. Thank you. Distinguished members of the panel, Honorable Chair, good afternoon. My name is Emma Fransen, and in the following 16 minutes, I will address the claims regarding the 3 measures adopted by Aldran. However, I will first briefly conclude the submissions of my co-counsel. She stated that the loan granted by Zurich's Bank to Desertix is not a subsidy, and it is not a specific subsidy. Under Article 1 of the Acm Agreement, and under Article 2 of the Acm Agreement, as it was not granted within the jurisdiction of the granting authority. Moreover, the subsidy did not cause serious prejudice to the interests of Coruscant, as there was no causal link between the subsidy and its alleged market effects, the loss of sales. Therefore, we conclude this claim regarding the loan. If the panel has no further questions at this time, but the submissions of my co-counsel, I will proceed with the claims alleged by the complainant regarding the 3 measures challenged by Coruscant. An export tax of 25% on the exportation.
Could you please clarify? I thought there was one measure that they claim violates Article 11.1. And then in response to a question, they said, if we find that that one measure does not exist, the panel still has jurisdiction to look at each of the components as a specific measure at issue within the meaning of 6.2. I understood that that's the argument. Do you agree with that position, that we have jurisdiction in case we find that the measure, the single measure, does not exist? Do we have jurisdiction to look at the components as being separate measures at issue?
Thank you for that question, Madam Panelist. Well, we know that, of course, the terms of reference state that it's an overarching measure. And we know that, for example, in EC large civil aircraft, the reverse happened where the measures were challenged separately, and a violation could, the panel therefore did not want to look at them as an overarching measure, as this was not included in the terms of reference. However, if the panel would like to deviate from this and conduct an objective assessment of effects under Article 11, it's our submission that the panel could not do so. However, that seems to be what the complainant is alleging in this case.
Is it a question of Article 11 or a question of Article 6.2 of the DSU?
I'm sorry, it's a question of Article 6.2, where the terms of reference clearly state that the measure must be identified by the complainants as an as a measure at issue, and they characterize this as an overarching measure.
Now, this panel would have done this ex officio, because
Mhm.
it's a jurisdictional question.
Yes.
But I'm a bit surprised that you don't emphasize this more in your oral statements.
Yes, but we do, of course, agree with the panel on this point that if the complainant would allege that each measure separately is a violation of Article 11, then they would have to include this according to Article 6.2 of the DSU in their panel request, which they have failed to do, of course, in this case. So, and we, of course, also submit that the three measures together do not form such an overarching measure as alleged by the complainant. This is because, according to the appellate body in Argentina import measures, as stated by the complainant, there must be interaction between the different components that constitute the measure, and the single measure must exist distinct from its components. And we submit that there is no such interaction in this case, as each of the measures are vastly different in nature. They do not refer to each other, and one of the components of this measure, the export registration requirement, nowhere in the case facts is actually linked to the alleged common policy objective the complainant refers to, being the Green Hope strategy. Therefore, these measures are not linked together as one overarching measure, as they are so different in nature. They do not relate to each other, and they are very autonomous in nature.
Excuse me, counsel. My understanding of the complainant's argument is that these measures work together to restrict export, not that they are linked under the Green Hope strategy. Is that although indeed, when we look at them, they have different purposes. I mean, allegedly they have different purposes, but the complainants claim that when you look at them all together, their effect is to restrict export. So could you tell us how that's not the case? Because when we look at the data that's been given in the case, we clearly see that, well, these measures do achieve this common objective of reducing export, because first, the export tax enter into force and then export decrease. And secondly, the export registration enter into force and then export decrease further. And then the mines start closing and then export keep on decreasing. So there seems to be a grand plan from your government to restrict export. So can you tell us how to separate these three measures?
Yes, thank you very much for that question. And the plan you refer to is also very pertinent in this regard, as we know from the case law of Russia Railway and Russia tariff treatment, that there was no overarching measure found when there was no common system or plan that linked the three measures together. And we here submit that there is no such system or plan. As rightly pointed out.
Counsel, I'm confused about this, though, because your co-counsel began the respondent's presentation by arguing about the environmental objective here. So it does seem to be the purpose that's at issue here. And I just wonder, isn't it, again, getting back to my circumvention point on jurisdiction, isn't there a similar issue here where a government can divide up its measures and even if the purpose isn't exactly the same? Again, that was the purpose that that your colleague led with. We have a situation of death by 1,000 cuts. In other words, that a series of measures divided up into a series of measures really has a compound effect, and in fact, an effect that is greater than the sum of its parts.
Thank you for that question. Of course, we know from the case law in Indonesia chicken, for example, that for this policy objective to be the glue that binds these measures together, it needs to be the rationale behind each individual measure. And we do not, to clarify, the objective my co-counsel explained does apply to each individual measures, but in a separate way. Each measure enacts its own proper objective relating, of course, as she stated, to the health and environment. However, they do not work together, as the complainant alleges, for the restriction of exports. As, for example, as rightly pointed out, if I'm not mistaken, by Professor Van Bosse, that that one of the measures, actually the mining permits, is an internal measure. How can we view this measure together with the other measure? How is this a common plan that would restrict the export? This is not the case here. and we follow the case law in Russia tariff treatment and Russia railway equipment, where they state that a system or plan is also, and it's also included in the terms of reference, that there is a systematic restriction on export. And we submit that this is not the case here, as the measures were enacted for different purposes related to the environment, and they're autonomous in nature. So they each exist in their own right, and there's no overarching measure.
Is your argument that an export restriction can never be made effective through an internal measure?
No, thank you, Madam Panelist, for that question. We just submit that an export, that Article 11 does not specifically apply to internal measure, as this would effectively restrict the power of our government to regulate such matters. If this would be the case, then all measures taken internally that have some effect on export would be violations of Article 11. So if that answers Madam Pellanist's question.
Can I ask a quick question on the, you brought up the export registration before. That seems, you said that was not part of a plan, but it seems to have been introduced around the same time as the other measures. And it also seems fairly restrictive to me. Would you agree that it has an export restrictive effect?
Thank you also for that question, Mr. Panelist. Well, we do not agree that this measure is linked to the other objective, as it does not refer to this. This is merely a measure that monitors the export of a certain product, here neodymium. And we know from case law that indeed, as was the case in Japan semiconductors, we do not deny that such an export registration requirement can be burdensome on export and can be a violation of Article 11. However, in the case of Japan semiconductors, the delays that resulted from these export registrations were up to 2 to 3 months. Here we see only delays of 2 to 3 weeks, which is just enough for the customs authorities to check all the requirements for this measure. And this is not a restriction on export in our submission.
So is there any other guidance except for that decision that you mentioned for us to assess whether these 2 to 3 weeks might be restrictive?
Well, we can make an analogy with, for example, the agreement on import licensing, where 60 days is relevant, is a sufficient period for customs authorities to check their requirements, and here we are within that range. But this is, of course, a parallel, as there's no other cases except for Japan semiconductors on this matter. Okay, if that satisfies the panel on this point, I want to reiterate that it's our submission that there's no overarching measure in this case, and it's also our submission that there's no quantitative restriction in this case, as I've explained, the export registration requirement is not overly burdensome on export. The mining permit renewal process is an internal measure which does not restrict export in any way. We are, of course, aware that this reduces export. However, there were still some mining permits granted, so this is not the aim of the measure to restrict export, and the domestic sales have dropped almost to the same amount.
But Council, your argument is basically assuming that we accept your notion that there's not an overarching measure and that we should look at each one of the three separately to figure out whether or not they're a violation of Article 11. Just for purposes of argument, let's assume that we disagree with you, that we agree with complainants that this is a single overarching measure. Is it then, you look at the data on the record, there's clearly been a significant diminution in the volume of exports. Why should we not then find that this overarching measure is indeed a violation of Article 11?
For a number of reasons. First of all, for a violation of Article 11 to exist, the measure must fall within the scope of Article 11. And we are aware of the fact that this scope includes any other measure, which can include an overarching measure. However, it's our submission that an overarching measure comprised of different elements that includes an export tax should not be included in the scope, as the scope excludes explicitly duties, taxes, or other charges. Therefore, we are of the view that the panel should not consider this overarching measure, this element of the overarching measure when conducting its assessment of Article 11, as it has never been done before in case law to include
an export tax in an assessment of Article 11. This has never been done before, and it's our submission that the panel should not deviate from this in the present case. So we do submit.
All right, and so let's assume we accept that argument. So then can we say that we would be finding that two of the three elements, the mining restrictions and the export registration requirements, those could fall within the ambit of Article 11? Again, just so let's assume can we do that? And again, assume that we have not accepted your argument that there's not an overarching measure.
Yes, it's our submission that even in the case where the panel would view, for example, the two measures together compound as an overarching measure, this still is not a violation of Article 11, because in this case, there's still not a restriction on export, as we see that the domestic sales have dropped with the same amount approximately over this period of time. And we also see that we cannot be sure to attribute the effect of this trade data, so the drop in export, to be sure that it is attributable to these two measures that would then be viewed separately. It could be the case that these effects are attributable exclusively to the export tax, which is excluded from the scope of Article 11. As we know from case law, in Argentina hides and leather, in the case of an alleged de facto restriction on export, a causation between trade data and the restrictive measure in issue needs to be proven. So we cannot be sure, or the panel cannot be sure in this case, that these two measures are actually the cause of this drop in export.
I'm still concerned about our jurisdiction. The measure at issue is this compound measure, consisting of three elements. Now, if you remove one element, do you still have the same measure? Is that still the measure at issue? Or are we talking about another measure, which is perhaps not within our jurisdiction?
Well, we have to distinguish the measures at issue and analysis of Article 11. It's our submission that the measure at issue is still the overarching measure characterized by the complaint. However, for an analysis of Article 11, the export tax should be excluded from this, or the effect of the export tax, as this has never been done before.
Okay, the overarching measure as identified by the complainant. Now, the complainant identifies that overall measure, that overarching measure, as consisting of three elements. If you take out one, do you still have the same overarching measure?
Well, it's our submission that then in that case, an overarching measure would still exist. However, before doing so, I see that I'm almost running out of time. Might I request a 2-minute time extension?
Yes, granted.
Thank you. Of course, the nature of the measure, the measure is still an overarching measure, including the export tax. However, it's our submission that an export tax should simply not be included in an analysis of Article 11, as this was not the reason why Article 11 was established. As we know from the panel in Colombia ports of entry, that the purpose of including Article 11 is to address quantitative restrictions, as they are not transparent, as they are less likely to be transparent, as they are more likely to restrict export. And therefore, we simply find this an important issue as a matter of principle to exclude this export tax. So therefore, it is clear that we submit that there's no overarching measure and there's no quantitative restriction in this case. However, even if
I have one question on this.
yes.
So assuming we find that the measure exists, is there any scope for us then to find that it does not violate 11.1? It's a bit the mirror question I put to the other party. From the moment we say the measure exists because of the nature of the analysis, doesn't that automatically result in the conclusion that there is a violation of Article 11.1? So that the two analyses can, in fact, in practice, are very difficult to distinguish.
Well, we agree with the panel to the fact that, of course, an analysis of an overarching measure has a bearing or an effect on the analysis of Article 11. It's very difficult to separate the two. However, it can be the case that an overarching measure is not a quantitative restriction. It's not an automatic thing that an overarching measure, if it is found, is always a quantitative restriction. We have to look, as established by the complainant, at the effects of the measure. And here there is no restrictive effect on export, is our submission. So as I have only 1 minute left, I will briefly touch upon the fact that it is our submission that this measure can be justified by an exception under Article 20 of the GATT, because each measure separately was included for the purpose of protecting human health and the
Excuse me,
environment.
Counsel, are you justifying each measure separately under Article 20? Or would you have to justify the overarching measure, which is the one found to be violating?
I'm sorry, I misspoke. It's the overarching measure in this case, as we have extensively discussed, that needs to be justified. So it's an alternate. It's this measure that is justified here, but my time is running out. Sorry.
Thank you very much to both complainant and respondents for your arguments in chief. At this point, I turn to the complainant to present its rebuttal. Please proceed.
Madam Chair, distinguished panelists, in response to the arguments brought forward by the respondent, the government of Khorasan raises the following points on rebuttal. First, as for what concerns the term within the territory in Article 1.1a of the ASTM, the respondent has brought forward that this term relates to the recipient. However, we would like to clarify that the panel in U.S. anti-dumping and countervailing duties China directly explained that, and I quote, a government within the territory of a member seems to connote a broad reading of government to cover whatever forms of government that may be present within the territory of the member. And then the quote, this shows that the term within the territory simply relates to the government and does not refer to the recipient of the benefit. As for what concerns the de facto contingency under the first claim, the respondent has argued that there is no export contingency in the present case. However, we submit that according to the panel in Australia Automotive Leather 2, the fact that an entity is the sole exporter of a product is meaningful evidence for de facto contingency. We would like to stress the similarities in that regard between the Zertics in the present case and how the sole exporter of automotive leather in that case that is equally export oriented, and ask the panel to follow the finding of contingency in that case. As for what concerns the benefit under the first claim received by the Zertics through the provision of land, the respondent has argued that the differences in price between ownership rights in the Jutland Special Development Zone and the Mos Eisley Industrial Zone can be explained. However, we would like to clarify that the benefit in the present case is the difference between ownership rights in the Jutland Special Development Zone and land use rights in the Jutland Special Development Zone. The fact itself that the Zertics obtain exceptionally full ownership rights constitutes a benefit in itself. In addition, the fact that the Zertics obtain the land use rights at a significantly lower price over the long term constitutes an additional benefit which has remained unaddressed by the respondent. As for what concerns the term jurisdiction under the specificity analysis in the second claim, distinguished members of the panel, we would like to reaffirm that it is essential to look at the object and purpose of the ASTM to interpret this term. We must keep in mind that the principle of effectiveness in treaty interpretation, as was held by the appellate body in US Shrimp, is essential in the present case. Considering the enormous growth of cross-border subsidies, the principle of effective treaty interpretation requires us to interpret jurisdiction broadly. If we adopted such a narrow territorial interpretation as the respondent brings forward, this would open the door to abuse of the ASTM. I would like to point out the example that my distinguished co-counsel brought forward with the agreement between two countries that cross-subsidize each other in the present case. Moreover, the respondent tries to support this position by referring to the legislative history of the ASTM. However, we submit that the fact that territory in this article was changed, the word, territory was changed to jurisdiction in this article, shows that the specificity analysis was not meant to be limited territorially. As for what concerns the overarching measure, we submit that the fact that all the measures, that these measures target the whole value chain of neodymium from the moment it is extracted to the moment it is exported, show that the overarching measure is indeed that there is an overarching measure that targets neodymium exports. My co-counsel has promised this panel to substantiate our submission that the overarching measure ensures that neodymium is sold domestically. We have made the calculations that Madam panelists required, and we would like to point out that the ratio of exports to domestic production was 75% in 2018 and then dropped to 62.6% in 2020, and that this supports our argument. Distinguished members of the panel, we hope that you will see through Alderman's veil.
Thank you very much to the complainants. I now turn to the respondents for rebuttal. You have 5 minutes.
Thank you. I will present the rebuttal for the respondents. First, I want to emphasize regarding transnational subsidies that when we would allow transnational subsidies to be included in the SCM agreement, that would allow that even developmental aid or post-war grants to legitimate sovereign entities that need the developmental aid, that even those payments could be countervailed under the SCM agreement. And where would it lead us if we would apply the SCM agreement without limitations? That would be contrary to Article 3.2 of the DSU that states that we cannot add or diminish the rights of the members under the covered agreements. And that would lead us to judicial activism by the panel. And therefore we request the panel to find that in this case, we are dealing with a non-liquid claim, as we have, for example, also seen in the case of EC Asbestos. And in that case, we must go back to the members, and there needs to be a renegotiation of the SCM agreement to include transnational subsidies. So therefore, transnational subsidies are neither included under Article 1 of the SCM agreements or under Article 2 of the SCM agreements. The respondent refers to the object and purpose of the SCM agreement, but as we have stated, the SCM agreement was drafted to address situations in which a government subsidizes its own domestic goods. So the object and purpose states that transnational subsidies should not be included in the SCM agreements. Moreover, regarding the arguments of the respondents on de facto contingency, I want to refer to footnote 4 of the SCM agreement that explicitly states that the mere fact that a subsidy is granted to enterprise that export shall not for that reason alone be an export subsidy. So the mere fact that a subsidy is granted to Desertics who export shall not for that reason alone be an export subsidy. We can take into account the export orientation of Desertics, but footnote 4 clearly states that that should not be the only relevant factor in this case. Moreover, regarding the benchmark of the land use rights under Article 14D of the SCM agreements, we know from the case of the appellate body in US Carbon Steel that the proper benchmark should be market-determined prices for the same or similar goods by private investors. In this case, the land use rights cannot be seen as same or similar goods, as they are different in duration, for example, and are also different in content. So therefore, we cannot look at the land use rights as a proper benchmark. And as we have established, there is a significant difference in the geographical location between the gently special development zone and the most icy zone. So therefore, there was no benefit granted by the provision of lands to Desertics. And that concludes the rebuttal for the respondent. Thank you.
Well, thank you very much to both the complainants and the respondents for presenting their cases. And at this point, the panelists will retire to speak about the next step. Thank you very much.
In the meantime, for all participants, first of all, if you may stay seated for a couple of more minutes, we are going to show you right now a special video message that we still received and that we are going to show you before the closing ceremony. And afterwards, you might join outside the lobby where we have put some drinks outside until the panel finishes the deliberation, when we might get back into the room for the closing ceremony. But stay seated for a couple of more minutes, and we have a special video message of Mr. Pascal Lamy, former Director General of the WTO.
Hello. Can everyone please take a seat for the video? Everyone in the back, please. We're going to
So thank you everyone for staying here in the room. Now I invite you all to the lobby. There will be some drinks prepared for you. Please enjoy. We will invite you back into the room when the deliberation is over by the panel, and then we can start the closing ceremony. Hello, everyone. Good afternoon. I see that most of you gathered here in the room. Welcome to the closing ceremony. I will give now the floor to Ms. Gabrielle Marceau. She will be handling this ceremony as Master of Ceremony, so maybe also a quick applause for her.
Thank you very much. I will say a few more words, but you know, we have an amazing panel today, and DDG Ellard, who's the chair of the panel, has to leave. She's a very important woman. I can tell you that as a staff, when I found out, sorry, the microphones are a bit funny, that DDG, that she was coming to become DDG, I thought, oof, changes will happen. Well, they have been happening. So DDG Ellard will say a few words of comments on behalf of all panelists, and then I'll take over with the prize, but listen to her.
Well, thank you, Gabrielle, but I want to be more modest as far as that goes, but thank you very much for that nice introduction. But I want to thank all of you. This is really an amazing event, just to see how much time the teams, the coaches have put into this since September is, it's really amazing to me, the dedication I know that it takes. And very happy, of course, to be hosting the final round and the awards ceremony here in the WTO headquarters, where we had such a successful ministerial just a couple of weeks ago. I can't help but put in a plug for that. So anyway, the future of multilateralism is safe and sound. I hope you'll be happy to know. But we've had 270 students from 100 coaches participating from the very beginning of this process. 73 teams overall from 28 countries. I think that shows really a broad interest in this process, and I hope it's been a learning experience. And then here in Geneva, we've hosted 25 teams from 15 countries in these last rounds. And I think that that's a tremendous reflection of your dedication and skill. I also want to thank my fellow panelists. It's been a pleasure being with them this afternoon. I've certainly learned a lot from them, from their questions and their dedication as well. And a special thank you, of course, to Marcus and Victor for their work on the note, which I think that they really were, they took so many issues that are not well settled and so many different facts that are very pertinent to the kinds of issues that the WTO is looking at. So they really threw some curveballs, to use an American baseball analogy, at you. And I think that that was just really wonderful to see how the teams would address that. So it took us a little while for us to undertake our deliberations because there was just so much to discuss. And I want to thank very much the two teams in the final round for their hard work and for their responsiveness and for their respectfulness to us, to each other as teams, and of course, as co-counsel to their co-counsels as well. So I will just end there by saying thank you to all, and I hope to see some of you next year. Thank you.
Thank you very much, DDG Ellard. So for those who, some of you may have seen me on the video on Tuesday. I wasn't here. So you know that I've been involved and close to the ELSA Moot competition for many, many years. And this is why it's an honor, but also a great pleasure for me to be with you today. I've been instructed by Marisa, who's one of the sort of a motor of the WTO system, but of ELSA, not to move from the microphone. So that's why I'm stuck here. I'm sorry. So I'll start, of course, with a few thank you before we ask each of you to come and get your certificate. And I'll say the thank you starting with the coaches and their advisors, and of course the teams, you, because this is your event, and you will see that it will remain as part of your career, and I want to say your portfolio, your assets, for many, many, many years. Thank you, of course, to all the panelists for judging, not only the final panel, but all of them. Thank you to the case author, Victor Crochet and Marcus Gustavsson. Of course, it's been mentioned already. And I want to take 2 minutes to thank the ELSA team in the WTO Secretariat, if you want. And I'm not talking only about the real ELSA team with the vice president, the president, and all the others, but I'm talking here about Irina, here, Marisa, Miguel, and of course, those of the WTO Secretariat who acted as panelists. So thank you very much. Sorry? Oh, sorry. Now, 2 words, many, it's a special and difficult time. I said it in the video, I'd like to repeat. I'm amazed by the capacity of you, this generation, this team doing ELSA in COVID, in part in person, in part sort of virtual, for your tenacity and your capacity and your optimism and the amount of work that has been put on this competition. Now, you've done other works, you've done exams and different things. You all know it's different. When people wonder whether they should join this competition, we tell them it's hours and hours, it's demanding, but it will stay forever. So the fact that you are finalists is terribly important, a great honor. I would not hesitate to give a recommendation letter to any of you if you ever need it, because the participation, and this is why we start with certificate of participation, is really a gold medal. And I say this because it was difficult this time. I heard that some teams had only virtual panelists and virtual sort of opponent. Others had only 2 panelists. Some had, things were difficult. People catch COVID still. So there were lots of change. This is why the ELSA team did amazing work. But it could be a bit discouraging. And I don't want to say that those who won didn't win. Those who won did win. But those who maybe didn't finish first also did win and also did amazing work. What counts is to have done the exercise and win the challenge of being finalists here in front of an amazing team of real experts. You recognize, we all know Peter van den Bosch, we all know Jennifer Hillman, they were appellate body members. I see John Adine, the Director of Legal Affairs. These are real sort of experts in addition to the others on the panel. So please, you should thank yourself. Before we call each team to receive a certificate of participation, allow me to thank the sponsors, because you will see it's again the real top international trade law firms. It's not a joke when everybody repeats that it's real life. What you do, it's real life. You do have hearing in this room. You sit where you sit with real panelists at the real podium. So thank you to Van Bell Bellis. Isabel is a partner there. They are the top platinum sponsor. The gold sponsor are Acm Gum, Stepco, Baker McKenzie. I don't know whether Claude Chase is here. He was? Well, okay. There's, of course, Sidley Austin. And as another sponsor, is Christian here? No. Well, they give money and they made this possible. And panelists, yes, that's true. Now, the main academic supporter is, of course, Georgetown University, and that's Jennifer Hillman, who does so much for students after having done so much for the world. Because among other things, she was EB member, as I mentioned. The World Trade Institute is also an academic supporter, and you recognize Peter van den Bosch here. There's also the European Public Law Organization, and there are two technical supporters, the WTO, and this year, UniJE, because you had their plenary rounds at Unimag. So that's for the thank you. And now we'll start the part that I find the most sort of almost emotional and romantic, where you will team by team come and of course get closer to the panel, receive your certificate and take photos. So, and we go by on order of numbers. The team, and please come sort of all together. So you all know your numbers. We start with team 2 from Singapore Management University. So I suggest, yeah, if you take a picture, they're all there. Maybe you come closer.
Yeah, I will give you.
Or maybe
We just go maybe closer.
yeah, just like this, it's fine. Just a photo. Oh, maybe I should go there. Maybe you should move it back. Ah, you give him the camera. Okay. All right. The team 4 from India, National Law Institute University. I will disappear. The team 5 from China, Republic of China, from Taipei, National Taiwan University. Big team, wonderful. Yeah. Oh, so we see, yeah. Use the cakes off. Thank you. From Switzerland. Oh, I forgot another Indian, sorry. From India, the National University of Study and Research in Law, Team 9. Oh, we have a lot of Indian deserters. Team 20 from Switzerland, the Graduate Institute. And their coach, Matthew, was interned with me for 6 months. We never talked about that. Wonderful. Yes. Oh, thank you. That is the University of Zurich. Wonderful. Georgetown University Law Center from the United States. Sorry. Yeah, I have to stay close. So, yeah, can you take the picture like this? Otherwise, Irina will scalp me. No, you're right. Go there. University of Geneva, Switzerland. Welcome, yeah. Move ahead, please, move ahead. Good. Oh, lots of tall people. in there. Thank you. You shake hands? No. Okay, team 28, Colombia, Universidad Externado de Colombia. That's a long flight.
You have one dessert. Wait till it.
Thank you. Germany, Munster University, University of Munster. Also tall people.
Yeah.
Thank you. Germany, Martin Luther University, Halle-Wittenberg. Oh, goodness, yeah, wonderful. Yeah, you're right.
Yeah, that's it.
Thank you. We forgot, it's my fault, I suppose. Team 23, National University of Singapore. Sorry, so this was team 23, National University of Singapore. Oh, yes, Michael, of course. My old friend, Michael. Sorry. You know, you can shake their hands. They're famous, but they're available. Small. Thank you. Team 39, Colombia, University of Los Andes Law School. That's also another long flight. Yes. Team. The pleasure of in-person meetings. Yeah. Won't happen often, so make use of it. Great. Yeah. It's really a funny camera. How can it see so white? Scene 41. China. China University of International Business and Economics. That's the virtual one. Okay, well, we'll send them. Team 42, Ukraine. Taras Shevchenko National University of Kiev. I think they left. They were a bit. Yeah, sorry. They go through tough. Team 45, Sri Lanka, Faculty of Law, University of Colombo. Huh? Wonderful. Previous winners. That's another long flight. Yes, it is. It's worth it. Thank you. And then we have 3 teams from Kenya. So team 49, Kenyatta University School of Law. Did you lose some partners or you did the battle alone? Alone, great. Thank you. Team 54. Kenya Catholic University of Eastern Africa. Congratulations. Thank you. Team 60. Kabarak University Law School, Kenya. Thank you. 61, Greece. School of Law, National and Kapodistrian University of Athens. Three women. Wonderful. Thank you. Belgium, 63, Leuven University. Congratulations. Great work. Thanks. Another team from Ukraine, Team 67, National University of Kiev Mohyla. Thank you. Another Indian team, Nalsar University of Law, Hyderabad, 76. They're gone. And the last one, but not the least, Team 79, Uganda. Uganda Christian University. So now we're getting into the price for specific items, and we'll start with the price for all teams. Because it's a very special and difficult time, there's a very special price this time that is open to all members of all the teams that did this round. And this is a 50% tuition fee for an LLM degree at Georgetown, one of the main sponsors I just mentioned. And this offer is not limited in time. They will take 2 per year, but it's not limited. So I really encourage you to keep that in your planning. So that's the first price for today, but open to all after your certificate. So allow me to congratulate you. And this year, again, because it's a difficult time, we made one of the prize, which is the spirit of the Jackson competition. Traditionally, it was given to one team. But the organizers decided that because all teams really made an effort, all teams made concessions, all teams faced frustration and pleasure. So this is a prize that we delivered this year to all teams. So you can even mention that in your CV. You receive, it's a very important prize. It's about the competition spirit and the fact that you all do it for the best system there is. So congratulations to all of you. And in that context, there's a new, as you may know, a Jackson alumni community where those with this prize would have a special place. But now you all have a special place in joining this alumni association, much, to come. And soon, next year, maybe you will become panelists. One day you will be at my place or on this podium, and you will also pass the message to future students. So this is all part of the prize that we give to you that you will yourself pass to others. Thank you. Sorry. Now, 2 sets of prize before we reach the end, and we go to the best written submissions. So you all know that there are 3 phases in this competition, of course, and the oral, the last final, focuses on your skills as orator, but advocacy before any tribunal requires written component, and in WTO it's especially important. So in a real dispute, and in this dispute, your written submission were the first contribution that you provided, and these are the ones that we will prize now. So there's 3 prizes. The first one is for the best overall written submission. There's also the best complainant written submission award, and Elsa named that prize under my name. So I'm very honored and touched each time. And the best respondent written submission is given to Valerie Hughes, who was at the time that Elsa started the director of the appellate body. And she's the one who supported the project and made even her staff sort of great submissions. So she was terribly important. So for these 3 prizes, we did it like on TV in Hollywood with an envelope and names. So we start with the best complainant written submission, the Gabriel Marceau Award. So who won that? Oh, yes. Team 63. Yeah, there are different gifts given by Elsa, the WTO, the DG. Everybody pitched in and gave prizes. Thank you. The second one is the best respondent written submission, the Valerie Hughes Award. Team 28. There's no chocolate, no worries, so nothing will melt. Congratulations. The best overall written submission award. It's like on TV, no? Again, Team 63. So now we go to the Best Orators Award. And as you know, the Moot competition is essentially about orator skill, although we just concluded that the written submissions are fundamental. So in Moots, as in real life, arguments succeed when the team is working together. This is why the principal awards in this competition are given to teams. Nonetheless, each of you is presenting arguments, and despite the support you receive from your team, and from your coaches, etc., some individual skills need to be sort of emphasized. And I'm sure that you would all agree that you have developed those skills during this competition. This is part of the whole thing. So there are 4 sets of prizes for Best Orator. So there's the Best Orator in preliminary sessions, Best Orator in quarterfinals, Best Orator in semifinal, and Best Orator in the grand final today. This is called the Wernersdorf Prize. Wernersdorf was at some point director of the appellate body, very strong experience in dispute settlement. I don't know whether he's here. No, he's disappeared. Oh, okay. So let's go for those prizes. So the first one, the Best Orator in the preliminary round. Amanda Halliday, Team 45. Thank you. The best orator in quarterfinals. Cheng Hang Wei, Team 05. So we're getting close to the end. The best orator in semifinal. I love it. It's like Hollywood. Hannah Mignolet, Team 63. And the last prize is for the best orator in the grand final. It's the Werner's Duke Prize. It's a beautiful prize. It's a full tuition scholarship for Miles and Trial. That's the WTI program. Excellent program. And the winner is Emma Hansen. Team 63. All right, so we're getting there. Okay. So now we're reaching the winners of the grand final and thus of the 20th edition, 20 years that European students started this thing. And I remember initially it was just a little thing. Look how it is now, 100 universities involved. So I will, first, we have to congratulate both teams. Of course, I've mentioned it, all of you, but those two finalists, because you displayed more than an impressive commitments and tremendous skills and tenacity. And both teams will receive an additional 1 year free access to the Jus Mundi platform. Good for your next case when you become real WTO lawyers. But for now, because it's so sort of important, I will ask Professors Hillman and Van den Bosch to announce the award of the grand final. No, they will come. Well, the envelope, you decided.
The privilege is yours.
Well, you can speak at the same time.
Well,
We start with the first.
oh, we start with the first prize and then go to the second, or we start with the runner-up and then?
Well, they usually start with the runner-up, but if we announce the runner-up, you also know who's the winner.
Yes.
So why don't we
You go.
immediately go to the winner?
Go ahead. Go ahead.
No, yours.
Well, the winner in the grand final, I'm not even seeing a team number, was our complainants in this case, team number 22. Team number 22.
The runner-up, the team from Leuven, team 63, the second, please come. So before we go to drinks and dinners and parties, before we close this event, let me give the floor to the two case author of this edition, Mr. Rochet and Gustavsson, to say 2 words. I'm sure they admire you as I do.
Hi, I'll be very short, but I know you all want to go for drinks rather than listen to me. Well, it was a real pleasure to be case author, and well, like first to thanks Elsa for selecting Marcus and I. It's been a long process, but mostly over the last few days, listening to you all pleading our case, it's been quite emotional and it's been a real pleasure. So thank you so much for participating in this competition.
I guess I'll just add, quickly echo Victor's words, say a big thank you to Gracia and the rest of the academic board that helped us a lot with the case. I encourage all of you to think about also becoming case authors one day. Next year, probably maybe coach a team, but then consider to stay engaged with the competition. It's been absolutely wonderful to see you argue our case. That's really been a highlight. So thank you so much.
So I'm going to say goodbye before I pass the floor to Mathieu, the VP, to welcome you again in the WTO whenever you want. Please do not hesitate if you come via Geneva or want to come to contact me via email. We all have the same sort of email in the WTO. It's my name, Gabrielle.Marceau. You will always be welcome in my office. If I can do anything, you don't hesitate. I wish you a wonderful evening. I congratulate you again and again because of your sort of capacity to deal with the reality and be winners. You're all the winners of this competition. And I end in asking Mathieu to have the closing words. Thank you.
Thank you. So it is a real honor to conclude after Gabrielle Marceau and a grand final that consists of all these amazing and honorable individualities. I myself am very glad to see every one of you here in room W after this closing ceremony. It has been a real pleasure organizing this. This has been a long process over a whole year where we had a lot of ups and downs with COVID conflicts and everything, but we see that we are still united here all together in room W. And it is my real pleasure to close this ceremony. I will not keep you here too long. I will just say, enjoy yourself. It has been a real honor hosting this competition for all of you. And I hope you will carry this for the rest of your life and think a lot back about Alderaan and Coruscant. Thank you very much.
I said, remember, you are great. And tonight you should celebrate because you deserve it. Enjoy it.
So a quick reminder for everyone, we still have some glasses that we can drink right here. And at 8 o'clock, we will have the awards dinner at Hotel Royal Geneva. If anyone has the address, it is provided normally in email. Rue de Lausanne. It's a transport right in front of the building. So you will find it probably. And I'll see you there at 8 o'clock. Thank you very much.